going to go ahead and get us started this afternoon. Hello and welcome to everyone who is currently listening. Today, I and my colleague Erin Torcello are going to be talking about the mental health impacts of COVID-19 on the workplace and what employers can expect as employees start to come back to work and beyond. I'm Teresa Rusnak. I'm a bond, labor, and employment attorney in the Rochester office, and I'm going to be talking for the first half of the presentation this afternoon. And then following me is going to be Erin Torcello. She's a labor and employment attorney out of the firm's Buffalo office. So this is our agenda for this afternoon. I'm going to start us off with the introduction, reasonable accommodations relating to mental health conditions, and then different leave laws that employers should consider as they start to think about mental health accommodations. And then Erin is going to take it away with confidentiality, harassment, and discrimination, and steps for employers. Please use the chat function at any time to ask us questions. We aren't going to take any questions until the end because we don't want to run out of time to do our slides. However, we will stay a couple of minutes past 2:30. I know this is only supposed to be a 30-minute webinar, but we will stay a couple of minutes after 2:30 to answer questions as they come in. If you'd like to stick around with us, you're more than welcome to do that. So to start us off, on March 12th, 2020, the World Health Organization declared COVID-19 to be a pandemic. And, that's something I think we focused a lot on, what that means in terms of the physical side of the pandemic. So in addition to the devastating physical toll COVID-19 has had, especially in New York and some other select areas around the country, COVID-19 also has profoundly affected mental health, and that's going to include the mental health of employees. Employers are going to see the effects of COVID-19 on mental health in the workplace, perhaps for months and even years to come. On March 25th, the American Psychiatric Association did a study on Americans' mental health, and 36% of people said COVID-19 was having a serious impact on their mental health. 59% said it was having a serious impact on their daily lives. 57% said it was having a serious impact on their finances, and 68% said they fear COVID-19 will have a long-lasting impact on the economy. It's important also to note that while we are going to be speaking primarily about mental health conditions and COVID-19 this afternoon, that stress from COVID-19 can also exacerbate physical conditions. The World Health Organization lists some of these, as does the CDC and the EEOC. And those include such things as asthma, shingles, migraines, autoimmune disorders, among others. So not only can mental health conditions qualify as disabilities and medical impairments in their own right, but the stress or co-occurring factors that lead to those mental health conditions or exacerbate them can also exacerbate physical conditions, which may require reasonable accommodations and special interventions all on their own. So starting off with reasonable accommodations, when we're talking about mental health at work, we begin where we always must begin, with the Equal Employment Opportunity Commission. They have specifically talked about mental health and the effects of COVID-19 on mental health in the workplace. They've said that employees with certain mental health conditions may have more difficulty handling the disruption to daily life as it has accompanied the COVID-19 pandemic. I think it's important to note that when we're talking about daily life, we're talking about work and returning to work, but we're also talking about remote work. So don't think that just because your employees are home or working remotely or working different jobs or reduced hours, that there isn't still an obligation to reasonably accommodate them for a mental health condition if requested. There absolutely is. The EEOC also says that, for example, certain conditions are going to be particularly related to mental health conditions and COVID-19 that might be exacerbated by it. Conditions such as anxiety disorder, obsessive compulsive disorder, or post-traumatic stress disorder, along with others, are particularly noted by the EEOC as ones that may be exacerbated by stress relating to the pandemic. So the ADA applies and the New York law applies when a mental health condition is considered to be a disability. So if a mental health condition or a mental health problem isn't a disability, you don't need to be so concerned about the reasonable accommodation and employee protection side of things. So the question is, when is a mental health condition actually a disability? And I think this is something that employers struggled with even before COVID-19, trying to figure out where exactly that line was and what the definition encompassed. So the ADA, the Americans with Disabilities Act, says a mental health condition is a disability if left untreated. It would substantially limit an employee's ability to concentrate, interact with others, communicate, eat, sleep, self-care, regulate thoughts and emotions, or perform any other major life activity. So that's the EEOC's definition of when a mental health condition becomes a disability. The New York State human rights law, for those of you in New York, you're familiar with this, they also protect employees with disabilities, including mental health conditions in the workplace. And their definition of a disability, including their definition of a mental health disability, is broader than at the federal level under the ADA. So under the New York State test, a mental health condition is a disability when it's an impairment resulting from a condition which prevents the exercise of a normal bodily function or is demonstrable by clinically accepted techniques. That's generally thought to be a pretty broad definition of what constitutes a disability. So keep in mind, even if you may not need to reasonably accommodate your employees under the ADA definition, there very well may be a duty to do exactly that under the New York State law. The EEOC also notes that a mental health condition can be a disability even if it's not permanent or severe. That doesn't necessarily mean it's not substantially limiting. When the EEOC says that, it's really looking at things like, as symptoms come and go, what matters is how limiting the symptoms are when they're present. So someone who's suffering with a mental health condition doesn't need to be permanently or severely disabled all the time or have permanent and severe impairments of their normal major life activities all the time. It can only be when their symptoms are present. Mental health conditions, the EEOC notes, like major depression, post-traumatic stress, bipolar, schizophrenia, and obsessive compulsive disorder should easily qualify as disabilities. And that's the EEOC's emphasis under easily right there. I did not add that. So if you're looking at an employee who's asking for an accommodation for any one of those disorders, it's a pretty safe bet that the EEOC and a court are going to view that as a disability that qualifies for such an accommodation. The EEOC also has guidance on employees requesting an accommodation for mental health reasons and what employers may ask an employee. So if an employee comes to the employer and says, I have a mental health condition, I'm going to need a reasonable accommodation, the EEOC has kind of green-lighted these questions as ones that employers can ask employees about the condition. So it's things like you can ask employees to determine whether the employee's condition is a disability. So you can ask questions to that effect, questions such as how does it substantially limit one of your major life activities? And you can list those as examples if you like. You can discuss with the employee how the requested accommodation would assist the employee to perform the essential function of the employee's job. So you can always tie the accommodation that the employee is asking for to the employee's job and seek out the connection between those two as you engage in that interactive process with employees. And you can also explore alternative accommodations that may effectively meet the employee's needs. While employees certainly are allowed and should be encouraged to suggest what accommodations might work for them, employers are also allowed and should be equally encouraged to suggest alternative accommodations that may meet the employee's needs just as effectively, but be much more effective for the employer at the same time. So that's just a little overview on the interactive process when you're talking about mental health conditions, and much of that applies when you're talking about physical health conditions as well. May an employer request medical documentation of a mental health condition before granting an accommodation? So the EEOC says that the ADA, the Americans with Disabilities Act, does not prohibit an employer from asking for medical documentation of an employee's mental health condition as part of the interactive process. So in addition to asking those questions that we found on the previous slide and engaging in that dialogue, employers are also able to ask their employees for medical documentation from a healthcare provider that the person is suffering from a mental health condition that would rise to the level of the disability. However, in times of pandemic, the EEOC specifically notes that healthcare providers are limited in their availability and their ability to see patients, even if they have availability. So the EEOC suggests that employers be flexible and be willing to grant temporary accommodations pending the receipt of documentation. So for example, if an employee says, I'm experiencing post-traumatic stress related to COVID-19, the employer could say, okay, you have 3 weeks to get me this documentation, and in the meantime, I'm going to grant you a temporary accommodation by letting you work from home. If that's something that would work for both the employer and the employee, then in 3 weeks, if the medical documentation has not arrived, or even if it has, that's a natural point then for the employer and the employee to evaluate whether or not that reasonable accommodation is working for both of them. So there's some examples of reasonable accommodations that the EEOC provides for mental health conditions, and some that we've added as well. So things like altered breaks, including scheduling work around doctors and therapy appointments, having quiet office spaces. Certain mental health conditions can be exacerbated by sound or light or some other type of external stimuli. So if those are things the employer can control, that can be a good way to reasonably accommodate an employee. Different work assignments. Some assignments might be easier than others depending on the scope and severity of the condition. An alternate schedule for the employee. Maybe it's easier for them to work at a different point in the day than it is at certain other points in the day, especially if they're on medication that are going to naturally make them experience side effects, say in the morning or at night or right after they take it. Altering equipment or clothing to make employees more comfortable. We're going to talk about the face mask and the claustrophobia example when we get to our case studies in a couple minutes, because I know that's been one that I've gotten a lot of questions about, and Erin has as well. But that would be a good example of when you could alter equipment or clothing to meet someone's mental health needs. Supervisory flexibility. The EEOC gives this as an example and says, you know, if you have an employee with a mental health condition and it makes it difficult for them to understand verbal instructions, you could ask your supervisors to write down instructions or communicate with employees in a different way. You can also, as always, especially as we learned in this pandemic, allow the employees to work remotely. And unpaid leave, we never want to forget, is a form of a reasonable accommodation for almost every disability. So one of the questions I've gotten, and I know Erin's gotten this as well, is can an employer ban an employee from the workplace because of a mental health condition? Generally, the answer to that is going to be no. Much like you can't ban an employee from the workplace if they have a physical health condition, you also can't ban them if they have a mental health condition. And I urge everyone listening now to be very careful when they're doing an assessment of whether or not an employee should be banned from the workplace, not to rely on stereotypes or prejudices. I know there are quite a few of those out there when it comes to mental health conditions, and it can be tempting to slip into that way of thinking. But according to the EEOC, an employer can only prevent an employee from being in the workplace if the employee poses a direct threat or significant risk of substantial harm to himself or herself or to others. That has to be an individualized assessment. It has to be based on objective evidence about the employee, and the employers must, even if finding that the employee could be a direct threat or is, consider whether there might be accommodations to reduce or eliminate that direct threat before barring the employee from the workplace permanently or before eliminating that employee's employment. So please be careful if you're considering banning anyone from the workplace because of a mental health condition. That's not to say that if an employee is threatening violence or some other type of property destruction or something like that that would rise to a criminal act or could against the employer or one of the employees or customers, that the employee is stopped from taking that kind of action. That's not what I'm trying to convey here. So talking now about leave as a type of accommodation, certainly when we're talking about employees with any type of health condition, including mental health conditions, we're going to have to look at different types of leave laws that could impact that employee's working schedule. So the first one is the Family and Medical Leave Act. If your workplace and employee is covered by the FMLA, so are mental health conditions. They are covered by the FMLA if they are, as usual, serious health conditions, which, as a reminder, means inpatient treatment or continuing treatment by a healthcare provider following 3 days of incapacity, followed by continuing treatment. So that's when it's going to qualify as FMLA. Paid family leave along with FMLA may also be available if an employee is caring for a family member who has a mental health condition that's a serious health condition. Paid family leave defines serious health condition the same way FMLA does. We know that we've seen a number of laws passed relating to leave for COVID-19. Different states have different laws on that, and the federal government has laws as well, so it's always important to check those out and see if those could possibly apply in a mental health scenario as well. Leave can be, as I mentioned, a form of an accommodation, and as such, it can also be available via short and long-term disability leaves under New York law, unpaid leave under the ADA, the Americans with Disabilities Act, and the New York State Human Rights Law, as I mentioned. Leave available under the employer's own policies. If you have PTO, if you have vacation, if you have sick leave, any of those things could potentially qualify or allow an employee to take leave on a paid basis while they're recovering or treating a mental health condition. Employers, especially as employees are returning to work and adjusting to these altered schedules, should clearly communicate to employees which types of leave are available to them and the duration of the availability of that leave. For example, if your PTO is going to expire, or if it doesn't carry over, or if you're going to subject them to a certain type of paid family leave that they can only get a certain number of weeks within a certain 12-month period. All those things are important to make sure employees are aware of exactly what their rights are when they're taking leave. So I have two examples here before I turn it over to Erin. And the first one is the one I alluded to earlier with the claustrophobic employee. So we have Main Street LLC, which has recently begun bringing its employees back to work, and it requires all employees to wear face coverings consistent with New York State laws and guidance. Carlos, a longtime employee of Main Street, tells HR that he cannot wear a face covering because it makes him feel claustrophobic. So what should HR do? So Erin and I discussed this one yesterday at some length, because this is one, as I mentioned, that we've both gotten questions about more than once. So when it comes to the face coverings, if you have an employee who is saying they cannot wear it because of a mental health condition, because of a physical health condition, there is a duty of the employer to reasonably accommodate that employee. Now, some of the things you can do for that employee are, you can keep that employee more than 6 feet away from other employees. Right now, the requirement to wear face coverings really only applies if the employee is within 6 feet of other people. You can allow the employee to work remotely. You can give the employee a different type of face covering. If they can't wear a mask or they can't wear a cloth face covering, you can consider something like a face shield, which is clear and may make the employee feel less claustrophobic. One big question that arises specifically on the issue of face coverings is whether or not employers may request medical documentation of the need to have the face covering altered or the need for the reasonable accommodation. Normally, I would say go ahead. Under the EEOC guidance, they let you ask for a reasonable medical documentation if someone's asking for a reasonable accommodation for a disability. The only reason I'm hedging on this here a little bit is because we do have guidance from the New York Department of Health, which says employers are prohibited from requesting or requiring medical or other documentation from an employee who declines to wear a face covering due to a medical or other health condition that prevents such usage. So that I feel is a little bit in tension with New York's other requirement that employees must wear face coverings when they're less than 6 feet apart. But I just checked that guidance again right before we started this webinar, and it has not changed. So our best advice, and I'm going to turn it over to Erin in a minute to see if she has any other thoughts on this. Our best advice is try to accommodate the employee without asking for the medical documentation, unless for some reason the employee is being specifically uncooperative or refusing any type of reasonableness in this process. Try to avoid automatically asking for that documentation in this specific case of a face covering. Erin, anything you wanted to add to that?
Thanks, Teresa. The only thing I would add to that on this question of asking for medical documentation, the Department of Health guidance that addressed face coverings previously dealt specifically with the executive order that required employers or employees to wear face coverings where they were dealing directly with the public or with a customer. And while it's still in place, as we're moving towards reopening, the guidance that the state has put out through the Forward New York, their reopening guidelines, they require face coverings if you can't socially distance, and don't seem to have the same restriction or requirement about asking about medical information. So as Teresa said, there is some tension there as to what direction the state wants to go in. And I think if you have a situation where an employee has said they cannot wear a face covering because of a medical condition, the best thing to do before you ask for medical documentation is talk to your attorney, because I think it's going to be a fact-specific analysis as to why you're asking for that information. So like I said, if you're looking for documentation on that, I would call your favorite bond attorney and have that conversation before you go ahead and do that.
I agree with that completely. So I'm going to turn to our second case study and then turn it over to Erin. So ABC Company has begun implementing sanitation procedures for its facilities. As part of this, employees are required to use sanitizing wipes after touching door handles. Ted, an employee of the company, tells HR that his coworker Sarah will not touch the door handles and makes Ted open and close doors for her in the office. When HR asks Sarah why she's having Ted open and close doors for her, Sarah discloses that she has obsessive compulsive disorder and is worried about COVID-19 germs, presumably from the door handles. What should HR do? So if you think back to a couple of slides ago, I told you that OCD easily qualifies as a disability under the EEOC guidance. So now HR is on alert that Sarah has a disability and frankly seems to be asking for an accommodation. So that interactive process needs to start right then and there, asking Sarah if there are other things that they can do for her that don't necessarily involve her coworkers doing things for her when they should be working. So again, working remotely, working at off hours, taking unpaid leave while she works on her mental health condition are all types of things that employers can do. And I am going to turn it over to Erin now to talk about confidentiality and or add any parts to that case study that she'd like to. And I'm sorry, I'm going back.
That's all right. All right, I'm going to go ahead and share my screen here. Give me 1 second. Oh, there we go. Okay. Technology win for the day. All right, so now I'd like to turn towards talking about confidentiality. And confidentiality is a topic that whenever we're talking about reasonable accommodations or disabilities within the workplace, this is an issue that we should be sensitive to. Just with the situation when we're dealing with someone's physical disability, if you're handling an issue relating to someone's mental health condition, the same confidentiality limitations apply. So typically the EEOC has said that employers can ask that an employee notify them in the event that they need a reasonable accommodation for a mental health condition. That way, the employer then has the opportunity to provide the employees with information about what accommodations are available and engage in the interactive process. And I apologize if you hear yelling in the background. It's my children outside playing, and unfortunately, I can't keep myself on mute when I am actually presenting, so I apologize if you can hear that. You can generally ask employees to disclose any condition which may require a reasonable accommodation. We should typically stay away from specifically asking someone about a condition. There are 4 situations, however, that would allow an employer to specifically discuss someone's mental health condition or ask questions about an employee's mental health condition. The first is the obvious one, where the employee has asked for a reasonable accommodation. Where they've asked for an accommodation, you'll begin that interactive process and start a discussion about what the symptoms of the condition are, or what the impacts of the condition are, and what accommodations may be available to allow the employee to effectively perform the essential functions of their job. The other time you can ask about someone's mental health condition, or really about their medical information in general, is after a job offer has been made, but before employment has begun. So this typically comes into play where an employer has a standard wellness check that their employees must go through prior to beginning work. It happens oftentimes in the healthcare industry. So the limitation there is you can ask those questions just so long as they are job related. And the questions are asked of everyone entering the same job, and we're asking everyone the same questions. We can also ask about an individual's disability, where we are asking them to self-disclose voluntarily that disability in connection with an affirmative action plan. And then once an offer has made and somebody's been working, we also are allowed to ask questions about someone's medical condition, including a mental health condition, where you have objective evidence that the employee may be unable to do his or her job, or where that employee may pose a safety risk because of his or her condition. As Teresa mentioned earlier on this direct threat issue, we've got to be very careful in making decisions or taking actions on this direct threat, under this direct threat analysis. So if you have an employee which you do think either is unable to do their job or does pose a safety risk, again, I would encourage you to reach out to your attorney to discuss your game plan and your strategy before approaching that employee and asking for medical information. As with any other type of medical information that we may receive from an employee, we have to be sure to keep any information relating to an employee's mental health condition confidential. That would include any communications you have with that employee about their mental health, whether it's in emails, Facebook posts, text message, whatever information you're receiving from the employee, you want to make sure you keep that confidential. That includes not only doctors, but therapists, social workers, any mental health or mental health provider that the employee may be seeing. And then you also want to keep confidential any information that you have detailing the reasonable accommodation you've made, because that document most likely includes information about that person's medical condition. As a standard practice, we should keep any information relating to someone's mental health condition in a separate file. So we should keep all medical information outside of the employee's personnel file and have a separate medical file. Access to that file should be restricted to people on a need-to-know basis. And who is on a need-to-know basis is really a fact-intensive question and on a case-by-case basis. And if you do have to share that information with someone's likely direct supervisor, it's really important to ensure that that supervisor understands the importance of keeping that information confidential. So our first case study under here. So Andrea has worked for ABC Company and is for 10 years. She's very open with her coworkers that she has an anxiety disorder. 2 weeks ago, Andrea told HR that COVID-19 has created increased anxiety for her, and that her doctor has placed her on new medication, which makes her tired in the mornings. HR has accommodated her by allowing her to come in late as long as she makes up the time later in the day or on the weekends. This week, Andrea's coworker was disciplined for tardiness. He tells HR that Andrea has been late all week and has not been disciplined, and he feels this is unfair. What should HR do? Well, let me begin with what they shouldn't do. The first thing they should not do would be to tell the coworker that Andrea has an anxiety disorder, and she's getting an accommodation for that disorder. So you want to play it very vague and say that my opinion would be that Andrea's situation is individual to her, that you don't discuss employees' personnel issues with other employees, and just leave it at that and leave it vague. Teresa, any thoughts on that?
No, I agree with all that.
So I want to talk quickly, because I know we're at half an hour here. I want to talk quickly about mental health in the realm of harassment and discrimination. And just as with any other physical disability, there is protection for employees with mental health disabilities or conditions which are disabilities, which protects them from harassment and discrimination. There has been some evidence from the EEOC that there's been an increase in harassment or discrimination based on mental health conditions in the workplace, or at least people have increased their willingness to file a charge about such harassment and discrimination. It is not crazy to think that in light of, or as a follow of the COVID-19 situation, that those numbers may very well rise. So we need to be careful to remind employees, and in particular our supervisors, because again, they're agents of the company, they can bind us, that we will not harass or discriminate against others based on their mental health condition. And as Teresa mentioned earlier, and I think this is a really good point, we really should try to work as hard as we can to avoid making assumptions based on stereotypes. So a quick case study. Bill works at Main Street LLC, and he supervises several employees, including Elliot. Elliot told Bill he's been suffering from depression since the start of the pandemic. Bill tells Elliot to buck up. Oh, sorry about that. And everyone's lives have been disrupted. Bill also gives Elliot a difficult assignment to take his mind off of things. Today, Elliot told HR that the new assignments are causing him even more stress and that he's going to ask his doctor to take him out of work for a week. What should HR do? So one of the first questions you might have is this a disability? To Teresa's point earlier on, severe depression will most likely be a disability. It's unclear from this fact pattern whether or not Bill has already been diagnosed with depression, or whether or not he is making a comment that he feels depressed. So, but for purposes of this, we'll just assume that Bill has a diagnosed condition of depression. So Bill's supervisor is telling him to buck up. Everybody's lives have been disrupted. Bill has to be sensitive to the fact that someone with a diagnosed mental health condition may be more sensitive to the disruptions and the chaos that has been caused by the pandemic than others. In terms of giving him bigger or harder assignments to take his mind off of things, this could be considered discrimination or retaliation. Even though Bill and Elliot are friends, Bill is still a supervisor, and if he's giving him harder assignments, he's treating him differently based on a presumed disability, which may be unlawful. So HR should talk to Bill and tell Bill that he can't treat Elliot differently, and also talk to Elliot now about either accommodations to his workplace, perhaps working from home, or taking other steps to accommodate his depression. And I'll quickly go through some steps for employers to think about as we begin to reopen and employees begin to re-enter the workplace. If an employee does disclose a mental health condition to you and it seems that they need a reasonable accommodation, you need to begin to have that interactive process and begin a discussion about whether or not the employee needs an accommodation, what type of accommodation they think they need, and explore various alternatives, both based on feedback from the employee as well as what you, the employer, think you can provide. And you'll also want to think about whether or not you need to ask for medical documentation to support the need for that leave. As Teresa mentioned, you'll want to also think about what other types of leave may be available to that employee, be it leave under the FFCRA, the FMLA, unpaid leave, whatever it might be. Oftentimes, when I'm advising employers who are engaging in the interactive process with their employees, oftentimes there's a written document that goes to the employee and eventually that employee's doctor to request additional information. You'll want to make sure that if you are writing that document. You want to talk in that document about what the employee's job duties are, discuss, ask the doctor or the employee for opinions concerning what accommodations may work to allow the employee to perform these essential functions of their job, and then provide a date for the employee to return that information. Because we're in a pandemic and it may be difficult for people to get in to see their doctor, you may have to have some flexibility on those time limits, as well as how you are receiving that information. Just on a more informal side of things, I think talking about these issues within the workplace, especially as you begin to reopen, and you are discussing with your employees what the workplace is going to look like from a physical standpoint. What people are going to be required to wear in terms of face coverings, how many employees are allowed to be in break rooms, all of that stuff that you're thinking about in terms of the physical space and how people actually exist in a workplace that is not their house. You may also want to think about talking about the mental health aspect of this, acknowledging that people may be struggling, and provide your employees with a reminder of your EAP program. You may refer them to the CDC or the American Psychiatric Association or the World Health Organization to read up on what employees may do to help cope with the mental health aspects of the pandemic. There are also some pretty good resources offered by the New York Office of Mental Health. They have a number of posters and other tips that you may find helpful to review before you go back into the workplace, or that you may decide to provide your employees access to. There's also an emotional support helpline that the state has put out, and the number is found there that you may decide to share with your employees. And then lastly, to help decrease stress and promote flexibility, there are a number of other things that you may want to decide to alter, at least in the short term. As Teresa mentioned at the beginning, we have very much focused on the physical toll, and frankly, there have been a number of deaths that have resulted from COVID-19. I've had clients whose employees have lost parents, have lost family members. And so offering additional bereavement leave may be something to help address people's stress. You may think about relaxing requirements of attendance and punctuality, offer increased PTO, offer some additional flex working schedules, including remote work. So even though we can reopen and go back into the workplace, you may decide that just because we can be in the workplace, we don't have to be. You may encourage employees to have an open dialogue about how they're struggling, and clearly communicate with employees about sanitation, hygiene protocols, measures that are there to keep them safe. With that, I know we had a couple of questions. I've not been able to keep an eye on them, and I know we're a few minutes over here, so I understand if people have to hop off.
Yeah, no, we completely understand. Thanks for staying with us. Don't ever accuse a lawyer of not taking all the time they can. So some of the questions we've gotten, a lot of them have been just on a practical level about the slides and whether or not the presentation is going to be available. We do make the slides and the presentation available through our clients only link on our website. Please let either of us know if you'd like a link to that. You can also email Kathy Purdy in our marketing department or any bond attorney that you're regularly in contact with, and they can get that information to you. I got a question about where you can find the DOH resource that I mentioned, the New York DOH resource that talks about the face coverings and not asking for medical documentation. If you just type in New York DOH interim guidance on face coverings, it'll pop right up for you. The language I quoted is about halfway down the second page, so you should be able to find that. We've gotten a question about where you can find posters and other materials that have been listed. You can find those at the New York Office of Mental Health's website. They're right there under community outreach. And I think,
Teresa, I actually just shared a link to the Office of Mental Health's website to all the panelists and attendees. So if you go to the chat function, you should see that link right there. Hopefully it works. If not, to your point, Teresa, you can just Google New York Office of Mental Health COVID-19, and it should take you right to that page.
Yeah, I think those are the majority of our questions. We got a question about how you keep information confidential from supervisors when they can just sometimes figure out who it is and what the employee needs, or what the employee's accommodation or potential disability could be. In that situation, obviously, if you're in a small company, you're in a small business, it's going to be harder to keep those types of things confidential. However, when you're talking about your supervisors, I think it's very important to specifically remind them that they are not allowed to disclose that information to other employees, and especially if they only think they know something and don't know it for sure. So that's how I would answer that. And I think that's the majority of our questions. I got a question about the face. Oh, can the face shield be used? I was under the understanding that a shield cannot be used as an alternative to a face covering, rather that it's only an extra precaution to the face mask. I believe if you go under, the DOH guidance should help you with this too, but if you go under the executive order that mandated face coverings, I think face shield is actually listed as one that can be a proper face covering. Erin, anything you wanted to add, or?
Oh, I was going to say, and I think the point there is the face shield would be offered as an accommodation,
Yes.
not as a substitute, a wholesale substitute for the workforce. It would really just be in those situations where the employee has indicated that they can't wear the face mask covering for whatever reason. Now, you may decide that a face shield is not reasonable for whatever reason, perhaps because it's not as protective, but those are, I would say more fact-specific, a more fact-specific discussion that you'd want to have in the event that is raised.
Yes, I agree with that completely. I'm getting asked for the name of the marketing person to contact for the slides. Her name is Kathy Purdy, and I'll give you her email address right now. And actually, maybe Erin, you can put that in the chat as well.
Yeah.
But it's kpurdy@bsk.com. All right, so with that, thank you so much for joining us this afternoon. As always, we appreciate your time and attendance to all of these webinars that we've been putting on, and please have a safe and healthy Memorial Day weekend.
Bye, thank you.
Bye, everyone.